Get your justice, paralegal school. We provide the tools, you do the work. I'm Coach Neighbors. We got a great response on the video that I did titled Attorneys Ethics and How to Control Attorneys in Court. We are going to focus on that a little bit more, and I'm excited to be bringing that to you guys. I mean, you guys know me, you know that this is the part of my job I get excited about, teaching people how to punch attorneys in the face, literally. I mean, in court, sorry. I said the wrong word. Anyway, yeah, that's what we do here. Going to teach you how to punch these attorneys in the face. And that video, I got 13 comments, and I'm still trying to go through some of those comments. So I'll get to them, but we're going to do some more on what you need to get control of the attorney situation in your case, or get control of your case in the attorney situation, however you want to put it. Is going down tonight. So let's get started. Oh, wait, before we get rolling, I need you guys to make sure you subscribe to my channel. Click on that bell so you get notification when it's time to rock and roll. Make sure that comment lets the algorithms know that you guys are bringing value to the table. Even if it's just, hey, great job, or whatever. Leave a comment. So let's get started. So one of the things that I have done, attacked the judge as soon as the judge stepped in to help these guys get by without proving jurisdiction or responding to our jurisdictional challenge with an affidavit by CounterAffidavit. And when the judge helped them, we pretty much sued the judge. Well, actually what we did, we filed for reconsideration, opened the case back up again, and then we objected, filed for reconsideration, and then we sued the judge, and the case was terminated. We just stopped playing. And what we did was we moved their state case over to federal court, interest of justice, and we moved it using the court rule, not statute. Statute is real restrictive, and they were trying to block us using the statute, but we already know that the statute is not a valid law. It's a policy. It's not a valid law because it does not contain the three elements that your state constitution mandates must be present for something to be a valid law. And that would be an enacting clause, a title, and a body. The state constitution mandates that these three things be present for something to be a valid law, and it have to be enacted. And policy and revised codes and statutes are not, none of them. So at the end of the day, at the beginning of the day, at the gate, wherever you want to call it, the foreclosure process is in violation of the Constitution because the statute that they're using is not a valid. Three elements necessary. Okay, you guys, I've done my homework. When we moved their case over to federal court, the cool thing about that, they were really mad. They were really, really, really mad. Judge ordered them to respond. And they're in a kind of a pickle now because they didn't jumped it up to 20 million and had served them court documents at their house. Oh, that was what they were really mad about. So it wasn't just the court documents that got served to the house. What happened was added the attorney's property, the attorney's house. She added the attorney's house to her lawsuit as damages. And she looked up the information on the internet and the attorney's name was on the property. So both parties who own the property have to be sued if you're suing them for the property. Sister added the attorney's wife to the lawsuit and served her own copy of the lawsuit at their house. Yeah, they were really, really mad about that. And so that's a great idea. Anything that you do that pisses them off is a great idea. I wonder how that conversation went with the attorney, when he was talking to his wife who's on the lawsuit for $20 million. And then the other people on the lawsuit are the judge, the state, and the State Bar Association. Wonder who they're going to get to represent them. Yeah, so I'm thinking that the spouse lady or spouse man, whoever, was really freaking mad and started bugging them. Yeah, I like that. That worked out great. So that's a tip you guys need to be keeping in mind. When you serve them or do your counterclaim, add the attorney's property to as damages and throw the spouse in there, the spouse name's on it, whoever name's on it. That's how you do it. So once we moved their case over to federal court, let the air out of their tires, they had to hire someone to help them. So they went ahead and used one of the attorneys that we had already struck down. And I think there were 7 or 9 attorneys, 7 or 8 attorneys maybe, that stepped up to the plate, but it was a little too hot in the kitchen and they had to go sit the hell down. This attorney that stepped up to help them, well, we ran a check on him and he has not passed the federal bar. So in order for an attorney to sign in and represent somebody in federal court, they have to pass the federal bar. Thank you to the consultant for letting us know that. Filed a sanction motion for $50,000 in immediate damages against the attorney for litigating a terminated case. Now we moved $20 million lawsuit over to federal court. They're trying to act like they weren't served or they didn't get the summons. Well, it turns out they didn't get the summons. For some reason, the clerk didn't give summons to fill out. Now we just went ahead and moved our $20 million lawsuit over to federal court also. We added a motion for summary judgment because they didn't respond to the lawsuit when we filed it in state court because they thought they had it in the bag. But it ain't in the bag no more. We moved our $20 million lawsuit over and a motion for summary judgment, and then we followed up with a sanction motion that is in most of your packages that you buy from me as a sanction motion. And we followed with a sanction motion, $50,000 for immediate damages because they didn't respond on the merits, obviously. And if they need more time, I can give them as much time as they want. As much time as they need, because we're not in a hurry. You guys need to remember when you're in this fight, you're not here to hurry up and get the judge to rule on nothing, because that's not going to help. That's not going to help you achieve the goal that you're trying to achieve. What you need to do is have your dancing shoes on, because we're going to be in the ring for a minute. That's how we do it. All you got to do is stay in the ring. And one thing that I learned too is that when the year ends, these corporations, they're a corporation. At the end of the year, they have to look at these cases and they have to have them moved over here and done all this stuff. They have all these things that they have to be doing or have done at certain periods of time, or it's looking like somebody ain't doing their damn job. So our goal is just stay in the ring, keep punching, and getting documents on the record that you need to use as evidence in your lawsuit. Usually what we have been doing is if the state judge jumps in the middle of it and tries to help them, then you'll file your lawsuit against the attorney, the judge, and the state. And this strategy messes up the program because, number one, the attorney is the one that signed and starts the foreclosure, not the lender. Nobody from the lender signs anything. The signatures are the attorneys on the notice of default letter, the acceleration, the cure letter, whatever, and also on the petition, the complaint, or whatever is only signed by the attorney. And you always want to add a copy of that to your lawsuit. So when they freak out at the clerk's office that you got the attorney as an number-one defendant, you can show them, look, my legal team told me to put the attorney on there because the attorney is the only one that signed to do the foreclosure. Nobody from the lender signed. See, look, flip it up and show. Nobody from the lender signs anything. You're going to sue some imaginary person that didn't sign? Oh, that's the problem that we've been doing. Following their structured BS, suing imaginary people, jumping through hoops, pretending things while they're taking our stuff. So we're not doing that no more in this program. Attorneys have a problem when you add them to the lawsuit as number-one defendant. They can't represent themselves. They can't litigate a case they're a party to. And people don't know this, but they can't represent the law firm they work for. That's considered pro se representation and is not allowed by the court rules. So once we got their case moved over to federal court, and this is really cool, for the first time ever, the judge ordered them to respond, in the 14-day time period. So that was like the first time ever that anybody ordered the attorney to do anything. So that was pretty encouraging. Now, when I say that, you guys keep in mind, this is not my first rodeo, and I'm not sitting over here thinking that it's going to be a cakewalk, because I know that the two courts are talking with each other and they're trying to help them out without getting their stinking neck stuck on a chopping block. The judge, in his attempt to help them out, put out an order and ordered us, well, he denied our restraining order, which we appealed. And he also ordered us to stay filing any more documents in the case pending the court's review on whether or not the federal court had jurisdiction, because the attorneys made some pretty good arguments. Oh, wait, well, the attorneys did not tell the federal judge that the case was terminated. The judge did not read the documents that we filed in court pointing that out. So, and we sued the state court judge twice. We're suing them again now. So I'm pretty sure federal court has jurisdiction. And if they want to keep playing, then we'll file the 42 U.S.C. 1983 civil rights package in their face and see how they like it. We just kind of giving them a little bit of rope because we're the ones running the show. Judge tried to give them a little bit of help, and so what we did was I just appealed it. I appealed them denying the restraining order, and I appealed them ordering us to stand down and not file any more documents in the case. So that's just really stupid. The judge has no say in what we file in the case. We file whatever we want, and then when it gets to where it needs to be, then it'll get handled. So we appealed it, and so that made the judge have to respond to the appellate court, and actually was the judge here and was trying to deny our appeal, and the appellate court sent us the paperwork we wanted to pay the $400 we could appeal. Well, we didn't really want to appeal. That wasn't our goal. Our goal was to let the federal court know that anytime they want to stick their neck on a chopping block, we're gonna like make them look like crap. We're gonna embarrass them, and we're going to file the appeal. But while everything stops while we're appealing, we're just going to sue the judge, because that's, look, it don't matter if you're a defendant or the plaintiff in a case. You're still supposed to be afforded some constitutional rights and due process and some other stuff. But we often don't get that. So until we get ugly and start suing people. So that's how that goes. When you add the person who signed and started the foreclosure proceedings to your lawsuit or in the counterclaim and their lawsuit, you can do it either way, it's a problem. The attorneys, they are forced at that time to hire outside representation. Now, here's the problem with that. When the outside representation attorneys find out that the inside representation attorneys are being sued for illegally collecting alleged mortgage, acting as a third-party debt collector, they will not help the attorney. This is what we find out. They will not help the attorney. They will not help the attorneys because they're doing the same shit. I'm just saying, they're doing the same crap, and that's why they won't help the attorneys. Because, could you imagine how that's gonna go? They're coming over here to get their back, and we know they're doing the same thing, so we'll just add them to the list. They have no credibility. This is a very powerful strategy if you have your game plan structured around it. The judge already got paid, and this is my opinion. The judge already got paid, so he or she will have to allow the attorneys to proceed in violation of the court rules. Now you can sue the judge with the lawsuit document in the package for helping the attorneys. It's almost like we set them up. That's how you do it over here. When the judge rules for them, you will use the reconsideration package to object to the judgment and demand reconsideration. This opens the case up again for another judgment. See how slick that was? Now you file the motion to recuse the judge for helping the attorneys, and then you file the lawsuit against the judge for helping the attorney. And now their vessel is floating around in admiralty jurisdiction without a motor, because without the judge, it can't go forward. Without the attorneys, because you sued them, the case can't go forward. So this is how we do it. Instead of arguing the lies, we take out the parties so the boat can't roll. That's what we do. Thank you guys for sharing your time tonight, and I will see you in the next video.